Okay, and we're live. Let's see here. I'm attorney James Betzold, for those of you who don't know me for some reason. And we've got a little bit of an exciting announcement to make today. I just did the same video in Spanish, so if you are one of my Spanish-speaking followers, friends, amigos, then you've heard this information already. But I had so much fun doing it in Spanish, I figured why not do it in my own native English as well, because it's some good news. So many of you know my webpage, one of my web pages is visafeliz.com. Okay, so Visa Feliz is like happyvisa.com. Well, that's just one of them. My typical law firm one is right here, betzoldlaw.com. I'm attorney James Betzold. But let's take a look at this. So we received notice today that the Department of Homeland Security is not going to defend the litigation that has to do with the enforcement of the public charge ground of inadmissibility or removability, right? So we're very excited about this. What this means is the implementation that was begun in 2019 under our former loser president, Donald Trump. And I say that lovingly because he did lose the election. For anyone who wasn't watching the news, he lost by many votes. But our ex-president implemented what is an unlawful policy change. So essentially, he took a piece of the law that said if you're ever going to become a public charge, or if you're likely to become a public charge in the future, you're inadmissible to the United States. You don't get a visa. You can't come in. You just got to stay in your own country, or you can't get your status here. Now, the law has never meant that in any practical sense. The law has always meant that you have somebody here who earns enough money, who's willing to support you if for some reason you can't support yourself. And what the law really meant at its core, and this was brought out in some of the litigation, is that if you're going to immigrate to the United States and all of a sudden you become a dependent of the court, right? Like they need to file for it. Somebody needs to get a conservatorship for you. You're dependent on the court. You're costing the court. And you need a judge or a supervisor appointed by the court in order to live your life, then yeah, then you're not allowed to get a visa because that would be a public charge. What the Trump administration did or tried to do starting in 2019 is they said, hey, let's make this rule so strict that it's going to be very hard for anyone to qualify, even if they have people who are willing to support them financially if they fall upon hard times, even if this person has a good education, has good work experience, and all these other things. And so they created what is known as the 2019 enforcement of the public charge rule. And again, that enforcement was done by, let's see, that Chad Wolf. He was the head of DHS at the time. And Chad Wolf was unlawfully appointed to be the head of the Department of Homeland Security. Now, what that means is, according to the Federal Vacancy Reform Act, there's a law out there that says if somebody is appointed to be the head of an administrative organization or an executive agency, if they're appointed to be the head of an executive agency, right, so someone that the president can appoint, if they're unlawfully appointed, then anything they do doesn't have any force of law. And that was one of the main arguments for fighting the public charge rule. So, of course, the Trump administration defended against all these lawsuits that were brought by nonprofits, by attorneys who have clients who suffered because of the implementation of this rule. And due to that, there were a number of federal appeal circuits that said, yeah, this is unlawful. That doesn't count. And it's gone even up to the Supreme Court in some of the cases. So now what the Biden administration has decided to do is they said, instead of us trying to make a new rule and have to go through all that process, here's what we're going to do. Instead of trying to make a new rule or fight it, we're just going to stop defending this lawsuit because we don't like it anyway, right? New administration, they're in charge of the Department of Justice, and they get to set the agenda for the Department of Justice as well. And that's actually a quicker way to implement the reversion back to the 1999 guidance on the public charge law, which was a lot more reasonable, right? In some opinions, it still wasn't quite enough, but you know what? It's predictable. It works for most people. And it's not absolutely ridiculous like the 2019 one was. So let's take a look here. I've got my screen shared so we can see it, but you can see here on the Department of Homeland Security's website, key points here. Today, DHS Secretary Alejandro N. Mayorkas, now he's the first Latino head of DHS, first immigrant head of DHS as well. He's originally from Cuba. Announced that the government will no longer defend the 2019 public charge rule, as doing so is neither in the public interest nor in efficient use of limited government resources. The 2019 public charge rule was not in keeping with our nation's values. It penalized those who access health benefits and other government services available to them. Right? So let's just take a brief pause here. I want to remind you, called the Affordable Care Act, known affectionately by just about everybody as Obamacare, right? And under that law, it's like it's part of the law. Depending on your income, that's what you qualify for. You file for it, and it's normal. But now immigration can say, well, that's a public benefit, and you're using it. So blah, blah. So it creates this sort of catch-22. Just absolutely ridiculous situation. So what this does is it puts our laws back in order. It reverts the public charge enforcement, which is still something that is real. If someone wants to immigrate to the United States, especially on a family visa or an employment visa, they need to prove that they're not going to be a drain on the U.S. public resources. And they do that by filing what's called an affidavit of support from the person who's petitioning for them. And the person who's petitioning for them, if they don't make enough money, they need a co-sponsor. And those people are legally bound to financially support the immigrant if the immigrant falls on hard times and cannot support themselves. So the system, the law, the public charge ground of inadmissibility still exists, but it's not being enforced in this radical way that it has been since the Trump administration tried to do this unlawfully in 2019. So if we look a little further, there's some other nice points to the announcement here. And I really like how it says this. President Biden's executive order on restoring faith in our legal immigration systems and strengthening integration and inclusion efforts for new Americans called for an immediate review of agency actions on public charge inadmissibility and deportability. DHS's review in consultation with the Department of Justice and the state and the federal benefit granting agencies is ongoing. All right. And so it goes into some of the details here about the different litigations that are still ongoing and that the United States of America is not going to try and defend those anymore. So we really need to remember the importance of attorneys in our system of law. I have a friend from Cuba who I was explaining how sort of the legal system works here, where a nonprofit, either an organization, whether it's an organization of immigration attorneys or some other organization, a nonprofit, can actually file a lawsuit on behalf of the interests that it represents, like immigrants or positive immigration laws. They can file a lawsuit against the federal government for something they've done, and they can force the government to have to defend their position in front of a federal judge. And my friend from Cuba was incredibly impressed that was even possible in any system of government, because of course you try and do that in Cuba and you're just going to die or go to jail, right? So there have been countless cases that have been brought for a number of reasons against the United States government, against DHS for drafting this new policy, this radical public charge enforcement policy. And there were a number of people who were saying when Biden first entered the White House, well, why didn't he just do this right away? And of course, the reason is because if you try and undo it right away via the rulemaking process, that could take way longer, and you could run into a lot more roadblocks than you are if you just say, you know what, we're going to let the court decision stand, and we're not going to appeal these anymore. We're not going to fight these cases anymore. And you achieve the policy objective. It happens more quickly, and it has the force of law. So that's our great little announcement for today. Congratulations to all the attorneys out there who fought on behalf of getting rid of the public charge rule or the radical enforcement of it. So many thanks to them. This is my website, visafelice.com. If you have immigration needs, you want to bring a family member, maybe you've dealt with problems with the public charge rule in the past and you're ready to go at it again, please reach out to us there. You can find us on Facebook. You can find us via Facebook Messenger, or you could call our good old-fashioned phone number right here at 616-396-9418. I'm attorney James Betzold. Thanks for watching tonight. We'll catch up with you tomorrow when it's not so late, when I am well rested and ready to attack the things of the day in my regular business attire and not this long sleeve shirt and suit coat. Thanks. Have a great night.